Lord, item 6, my lord.
6.
My lord.
1 to 10 generally they are not mentioned. Kindly wait. Any urgency? Very urgent that you cannot wait for 10-15 minutes. You will wait.
Lordship, may I mention virtually, Lordship?
I may be pardoned, Lordship. It is for listing of the matter, Lordship. That is not on board.
Wait, mics are yeah.
Pardon, Lordship. This is two matrimonial appeal. The same appellant. This matter was admitted in the month of January. It was specifically adjourned to
What listing?
7th. My lord, 7th.
So give us some time, three weeks after.
My lord.
Give a date after 3 weeks.
Lords, may I mention virtually, Lordships?
Pardon to mention item 22.
20.
22.
22.
22. I place on argument. Next week any date. Mr.
22 you are there.
Yes, I am appearing the respondent of food.
Yeah, you have not been informed.
Yes, I am ready.
You are ready.
Yes, ready.
You are for the appellant.
I am for the respondent of
Respondent. Your friend wants time. Can we give?
Next week might be of minors. Next week any time.
But are you paying? So that's, are you paying if it is directed to you? Any amount is directed to be paid by the husband to the wife.
Wife.
No,
Nothing.
Service.
My lord.
Lordship, may I mention virtually?
That's, sorry, forgot the number.
20.
Which number you mentioned?
22.
22.
22.
Date
Lordship,
करो
may I mention virtually?
जल्दी करो तो ठीक है.
Lordship, may I mention?
Date. 23rd.
23rd. Okay.
Lordship, I am in virtual mode, Lordship. May I mention a matter, Lordships?
Yes.
My lords, a fresh matter of 6 writ appeals. My lords, it is covered by the judgment of the Supreme Court and part of the state in 1-2 districts have already been complied, Lordships. Lords, may take it up any day next week after Monday, my lords. I'll do it physically. Covered matter, Lordships, regarding multiple health workers, my lords.
Week after next we'll have. Next week because our calendar is not that free.
Then any day, my lord, not a Monday, Lordships. Requesting.
15th or 16th?
Please, Lordships. Any specific date? Otherwise, my lords, there is a problem with the listing. If it is on next week only, date may be kindly.
16, 67.
Please, Lordships. Great.
My lord, it is a press.
Not Monday. Other than Monday.
Other than
My lord, it is a fresh matter. We are challenging.
give it. Fresh matters will be listed. Little bit patient. Be patient because we are taking up old matters fast. Please call it.
My lord, especially serial number 11, my lord. Similar matter mentioned. That matter also put down same day, my lord.
Well, I will do it physically, Lordships. Item 11 minutes.
In bracket to be tagged with so and so. So, or else they can't understand. Mention 824284023. Give the memo. Give the memo.
Man.
Posting it to 16.
Please, Lordships. Grateful, my lords.
Page 4, 21.
Nobody, only one person. Yes, brother, what do you know? Call over.
Item 1.
My lord.
Yes.
Can you pick it up next week, my lord?
You wanted time in this matter, na?
My lord.
All right. Week after next.
My lord.
At the request of learned counsel for the appellate, call this matter in the first week.
Sir, my name may be recorded. I am on behalf of Union of India.
Sorry, so appears for call this matter the first week of August.
My lord.
First week of August.
Item 7.
Well, RCP, the petitioner before RCP is a new nursing institution and it has SL Annexure 8, your Lordship may kindly turn to Annexure 8 at page 36, Miller. That is at page 37 of your Lordship, Miller, Annexure 8. That is the decision of the DMET, which is the chairman of the council, that is ONMRC, that is a nursing institution matter, Miller. And that decision not to recommend, and my name is the petitioner name, next page your Lordship may kindly turn to at serial number 86. Have your Lordship got 38 page, Miller. Serial number 85, that is Nityananda Institute of Medical Science, that is in the middle of that column, Miller. And the region is, the solitary region is, that is in the extreme left of right side of that column. Your Lordship may kindly appreciate. Building plan and completion G3 mismatch with the fire safety certificate form B floor.
Identical matter we have considered.
Yes, Miller. Miller, I have got the information.
8. Posted to?
Posted to 10th, Miller.
10th of July.
It will come. We have this on 10th.
Your Lordship, it is your Lordship order in identical case. What I have ordered.
We only are telling that.
Yes, sir.
Yes, Miller. Now I am providing for your Lordship convenience.
Third, look at counsel Sri frames for appearing for the petition. First off, he submits that the fact matrix of this case is substantially similar to the one in WP number. So it's write down.
Sir, WP number 16740 of 2025. 16740, I'm repeating that.
25. Wherein already notice has been ordered on the opposite parties. And therefore, same course may be taken up. First, we agree. Tenth, issue notice to the respondent. First off, Shri.
Arshiman.
First respondent, second respondent, third respondent. For who appeared?
First is state, Miller.
Second and Mr. Mohanty, London ATA, on our request accepts notice for the first respondent. Yes.
Director nursing, I think he is also going to appear.
No. I am to appear.
Director nursing also?
Yes. No, director nursing he is to appear.
So what you are saying?
One end.
DMT for DMT.
1 and 4, sir.
1 and 4. Right. So 1
You are for DMT and nurses and midwives registration.
Yes, for 2 and 3.
For 2 and 3.
2 and 3.
Yes, ma'am.
For 2 and 3, subject panel counsel Shri
Arshiman
appears. First off, petition papers to be served to the counsel appearing for the respondents right now.
Yes, Miller.
Call this matter when this matter is posted. Whichever date.
Oblige for this.
Yes.
Item 10.
Fourteen.
Malad
Yes,
is an intra-court appeal. Then there is a admitted delay for 38 days.
30 days.
You get to the pensionary benefit and the matter is already covered by the Honorable Appeals Court decision also.
Saying that Narasu Pradhan and Varcha Jamble already Malad has fixed it on 7th. So for the job contract and let it be after that, I think it will.
Depending upon that judgment.
So can we issue notice or you will wait for 7th? Simply adjourn.
You don't want to appear.
No, I am appearing to sole respondent.
And Learned Friend has entered
We are not
appearance.
admitting. We are not a delay. We will condone delay.
Yes.
We are not admitting. Short delay of 30 days. 30 days.
No, 37 Milord as per
37 days.
48 days.
48 days.
Office note is 48 days.
48 as reported.
48 days. Is condoned by allowing the application supported by the affidavit since delay is short and plausible explanation is complete. Call this matter. On which date we have put that?
The sorted pensioner.
Okay. We'll call this matter in the first week of August.
Yes.
Because in that judgment, let us see what that judgment happened. Then that will be applicable to you also.
I am not the job contract. I am a WhatsApp employee.
So where are you? Please be present on 7th or your matter is there
Yes.
on 7th.
A copy.
His matter is also there.
His matter is also there.
Also there in that matter.
on
So you saw copy.
7th, my lord. It was
Seventh.
fixed to 7th. My lord,
this we will have it on 22nd then. 22nd.
July.
Yes.
July.
A copy of the
Give full papers, full set of papers. Yes.
Item 15.
Yes, sir.
There is a delay of 110 days.
110 days.
I have absolutely no objection. But here is so far the maintenance of the single writ
No, that
application.
will come to. That will come.
I am saying 12 writ applications are disposed of by the common judgment.
Common judgment.
They have filed one appeal. Is it maintainable?
First, suppose if I buy 1 dozen banana, I return only 1 banana.
Sir,
The rest of the rotten bananas I retain.
That is what I am trying to impression also. There are some certain judgment which has been relied upon by this court also. Incidentally, I was also a counsel. There the question was a writ appeal against order passed in different writ applications, maybe a common order, but they have to file a writ appeal separately. in each case.
That way.
Because separate cause of action.
Separate cause of. That's right. That's right. That's right. I was under the impression that in all those matters, if you want.
No, I cannot go to it. And
Yes.
and the whole question for consideration, it's a limitation that is for your lordship. Whole question for consideration, admittedly these persons.
Same order which we made, na? 100 on this.
The only question for consideration they have been appointed pursuant to an advertisement through.
Let us see your appeal.
Yes.
Let us argue.
Yes.
My lord, I pray some time because
What time?
Then next week also keep it to next week.
Next week, we have little difficulty. We have pushed it many other matters.
Yes.
Week after next week.
Or
Some days, week after next.
Item 16.
But they have to give heed to what learned seniority
that the
would say.
analogous matter can it be single out or in analogous we can.
Apex court said, what he says is right. Apex court said, suppose a batch of matters have been disposed of by a common judgment, but you prefer an appeal in only one of the matters. Then, only one of the matters, if you succeed, only that order is set aside. For in the remaining cases, that will remain intact only.
that means that is the res judicata.
Correct, res judicata.
Item 16.
Yes, sir.
60%.
Made decision appeal against the order of the Honorable Single Judge Bench of this Honorable Court.
Yes, sir.
And the appeal by
What is your, what was your grievance before the learned single?
the order of the appellant. The appellant has referred this appeal because the learned single judge of this Honorable Court has not assigned any reason as to why the order has been quashed. Why the order of the learned commissioner of land reforms has been quashed.
Commissioner of Land Reforms.
Again,
What order he had made?
37 of the Consolidation of Holding and Fragmentation of Land Act, Section 37, the commissioner is the highest authority to hear the revision.
Revision.
So
In the revision, what order he had passed, what he had said,
he has,
what the commissioner had said.
the commissioner has the revision petitioner has applied before the commissioner her to settle the land in his favor and declare his right title, interest and possession over the land in question.
As a tenant,
As a tenant, as a purchaser.
as a purchaser.
Aye.
Which is that section?
37.
37. Which act? Which act? Act is
37 of the Fragmentation of and Consolidation of Land Act.
This one. Land Reforms.
37. The Consolidation Commissioner.
Just give
reads
us a
as
moment,
follows.
sir. Just give us a moment.
The Commissioner of Consolidation.
Can
Yes, Mr. You are Mr. Raut.
Bigger pardon?
Mr. Mahapatra. Sorry.
Mahapatra?
You are referring to which section? 37.
37. The
37.
Consolidation Commissioner
Just let me get the page.
may call for
Power to call for record. It's like revisional jurisdiction. The Consolidation Commissioner may call for an exam. The record of the case decided proceedings taken at the use of subordinate authority that is not himself as to the regularity of the proceedings or as to correctness, legality, propriety of the to possibly consider. The case of person may, allowing the party concerned a reasonable authority to make such order. As it means, power under subsection 1 may be exercised by the director of consolidation in respect of authorities subordinates. So any order made by an officer below the rank of, not below the rank, subordinate to the commissioner, consolidation commissioner, he can call for that order, look into that, whether it is rightly made, wrongly made, ought to have been made, ought not to have been made, that he can decide. Though it's a revision, the scope of the revision appears to be little wider than the section 115 CPC revision. Because words are like that. Many phrases have been used to look into all the building blocks.
my submission is that the petitioner who was the petitioner before the commissioner, the revision petition was dismissed.
Dismissed. Against what order you were there before the commissioner?
Against the order of the consultation officer.
Consultation officer.
Aye.
Order dated?
I have referred this appeal against the order of the Honorable Single Judge.
That's all.
In fact, record of
Yes, indeed.
correction of record of right under section 15B is like instead of 15B they have filed 37(1).
No, so that's the principle that mere
Section may not be. Section may not be.
Whether 15B power is exercised, that is important.
Same officer.
Same option.
Same
How can
officer.
it be?
But how can you set aside?
So therefore,
How can you decline to refuse to decline the exercise of revisional power?
37(1) that commission has
You are
recorded
saying
is
suo motu power cannot be exercised when a application is filed by somebody, a private individual.
right.
But is there any case law on that?
I have to solve that. Therefore,
I mean, not you are
therefore,
saying that
honorable
the
single
conclusion of the learned single
judge
judge.
on submission of the counsel for the other side rulers, paragraph 4.2, page 52.
No, what was that order of consolidation officer
That is directed to record the government land in name of the
in his name?
yes,
That order is set aside.
set aside by the single judge. That is the
Set aside by the single judge.
yes.
The consolidated
That's the
commissioner
instance of his opponent.
Other side,
declared the land to be recorded in the name of the government
Notice may be
and
included, other
directed the
side.
parties to go to the lowest grade of the court. The
Civil court.
Aye.
Civil court or revenue court?
sir.
Revenue court.
Revenue court. So the appeal was, since the revision was dismissed, we would have approached the lowest court in the revenue administration. But in spite of that, the opposite party in the revision has
Approached the
preferred the
Writ petition.
before the Honorable Single Judge.
Were you notified by the learned single judge?
Beg your pardon?
Whether notice was issued to you. Notice was issued to you.
Aye.
You should have told the single judge that matter should be remitted back to the jurisdictional authority.
Oh, that is what I have. Why I have preferred this appeal before your honor.
No, that's all right. Did you tell it to the learned single judge?
We have told, but this order is like this. Your honor, your lordship may be look to the order.
So can you bring to the notice of the court a provision where such power is there? Kindly look at the order improved.
Single judge order ta dekham sir. Single judge order.
Improved order ta dekhantu sir.
52, page 52, paragraph 5.
52 সেটা দেখান্তু ঠিক।
Paragraph 5.
Para 5 টি দেখান্তু।
Mr. D. Dev, learned counsel appearing for the private opposite parties. Those
Just give us a moment. Just once. Yes. Carry on. Please carry on.
Though supported the impugned order and contended that such an application under section 37(1) of the Act is entertainable. But this court, after going through the provision contained under section 37(1) of the Act, is of the view that no such application is maintainable with the prayer as made in the revision petition at the instance of the private opposite party.
So, sir, the court's query is that this power can be exercised under which provision? Other than 37(1), is there any provision in that OCHPFL Act 1972?
That has not been mentioned by the...
Correct, sir. According to you.
You know.
We are asking you.
We would have go to the court below as per the order of the Honorable Revisional Court.
37(1) power.
Private party.
37, after 37(1), that is
There is no, it is not, section 37 is not party specific. It does not say any person aggrieved, any party aggrieved. It is
so
not
much.
party specific at all.
So much power.
Which is the best judgment on this section. This is a very old section, old act, na?
Yes, yes.
Any judgments of this court?
And I'm so sorry. That is there.
Because Apex Court said in one Bihar matter where revisional jurisdiction is not party specific, anybody can move revision petition, saying that I am aggrieved by them.
Or so much.
But if law says suo motu, then suo motu, not or suo motu. Suo motu can be done only if the statute authorizes suo motu, not otherwise. On his suo mata, he cannot do. He has to do if the statute authorizes him to do. Number one. Number two, why learned single judge is saying that the private opposite parties, it is not maintainable at the instance of private opposite party. What is meant by that? May not be correct. It appears to be little contrary to the jurisprudence concern. It was me. An application by any person it is. Person, like Lord Macaulay will say, every person, any person, that way any person.
Referring to 36(1).
Why learned single judge is saying that it is not maintainable at the instance of any person? What is support base for that? It is not that for the first time this question is arising in this court. Act is of 1972. Perhaps you were not born also. You were not born in 72. That old it is. Therefore, there must be already judgments of this court on this section, which is the standard commentary. Who has written a standard commentary on this act in your state?
This bare act.
This is the
Contents, they have to be gone through.
How? Why he says? Because Apex Court said in Bihar matter, the revisional jurisdiction are a kind of separate supervisory jurisdiction. And they can be exercised at the instance of anyone, unless the section itself says. You should notice. You take notice that question appears to have been decided in this way.
Private respondent is there.
How many days delay?
Delay is 18 days.
18 days.
Lordship confidence.
Hello.
Limitation petition has been filed for condonation of delay.
All right. Unless you have some objection, we will allow the application. We will allow the application. 18 days.
And
Take
the-
notice also. Requires a deeper consideration.
Yes, yes.
Yes, any interim prayer you made?
yes, the order of the Honorable Single Judge we stayed.
Okay. Will, brother, a case is made out because
Yes,
learned single judge says
because
that
there
may
is no
not be
legal
correct.
order. Private opposite party is there, lots of issue. So that
Issue emergent notice. You appear for whom?
I am for one, two, one, two.
He's not generally they are not.
The Tahsildar or some other authority was party.
No.
No, you have to
Only
go-
State of Odisha, Commission on Land Records, then private.
At least state should be made a party because
Yes,
the
state is
government
state is
You take notice for
Custodian of records.
Okay. You take notice for
Tahsildar.
State of Orissa has been represented by the Tahsildar.
Tahsildar.
Tahsildar cannot.
Anyway, you take that, no problem. Learned AGA on request accepts notice for official respondents.
1 and 2.
1 and 2. First one. Issue emergent notice to private respondent. First one. Interim order suspending the impugned judgment of the learned single judge is accorded since a prima facie case is made out as to the scope of revisional power in terms of section 37 of 1972 Act. First, comma, till next date of hearing.
Item 17.
Made legal.
Yes,
There is a delay of 90 days.
first one published somewhere of the sea. Has not that conversant with the Kurdish systems. Yes, sir.
There is a delay of 90 days. The Lordship has issued notice on the question of limitation. My learned seniors are also appeared and filed an objection.
So university appeal.
It's the university appeal.
How many days delay?
90 days.
Who appears for the respondent?
My learned senior is appeal.
You appear for respondent?
Yes, ma'am.
What is the point involved, brother?
Yes, this is a case of Honorable Singleton, sir, Director for Regularization. Our stand is that there is no post, and earlier direction he has approached this Honorable Court. Then division bench of this court has directed to give him regular appointment, and he will not claim any regularization. So,
There was a direction to give regular appointment.
yes, madam.
Did you give that?
No, madam.
Why?
Honorable Singleton, we have challenged that division bench are directed to give him the ad hoc appointment, and his continuance is subject to regular appointment. Regular selection is made.
How many years he has put in service?
He has
57 years. She is, it's almost
How many
57.
years you have served?
I have served from 2009.
2009.
yes, ma'am.
Yes, ma'am.
And the entire problem is there is no post. And
Now why did you continue for so long
in
years?
compliance to my Lord's direction,
Then now we will give one more direction to make him permanent.
my Lord, there is no post.
No question.
There is no post.
There is already order.
If your Lordship
For that reason,
my Lord, your Lordship is the read petition at Annex of 2. In read petition, ma'am.
In writ petition.
In read
So under appeal, they don't put this all writ petition papers. They should. You in appeal memo,
in not
you should produce all the
yes,
material that was before the learned single judge.
Annex of 2 you have opened? Sir, it is here.
direction was made to the finance department, government, as well as the university.
The Lordship wanted to see the order passed by the division bench, coordinate bench. Mr. Khutia.
yes, ma'am.
Yes.
So that is in writ appeal or writ petition?
Read petition.
Where is that judgment?
Division bench order.
Of the year 1994.
Where is that judgment?
That we're asking to see the page.
Judgment of Annex of 8. You also may see that page 21 of my counsel filed before the
Honorable single judge.
No, that is
I can
running page 50.
yes, ma'am.
50 click करो.
My lord.
That one.
That
Let's go.
order dated.
Let us get there.
My lord, you got it.
Yes.
Page number?
51. So the
22.
next scroll down. That one. It's 22. Running page is 51.
Yes, my lord. Lakshmi Siddharth order.
First petition is showing the concerning without the so right. Is put in the on regular basis by the authority. That's all the operation. If the vacancies exist, then it's a action taken by the university within from today. If the vacancies do exist,
Yes, my lord.
your case is no vacancies do exist.
I am clarifying. At that point of 3 vacancies are there. 2 for unreserved, 1 for ST. So he belongs to unreserved category.
So no post is available.
No post is available. At 2 posts of unreserved are there. 2 persons out. A selection test was held. 4 persons were selected under UR category. First did not join. Second, third, we have given them appointment against UR post. His position was at serial number 4. So he could not be given appointment at there cannot be appointment against a reserve post.
Did you show this order to the learned single judge?
Yes, this was annexed to my counter. And Honorable Single Judge has also directed us to file an affidavit stating the vacancy position as to why he was not given appointment.
You said that no vacancies are available.
Yes, we have clarified that because there is no vacancy.
Yes, brother, requires consideration.
That was not clarified. My case is that in the year 1994, I appeared the interview, vivacious and written, and was selected in serial number 4. And thereafter, they did not give appointment. Due to
Mr. Mahapatra, kindly, what has been deliberated, I'm so sorry. Mr. Mahanti, please consider the date of the order. That is
date of the order has been quoted in the writ petition.
24. No, kindly look at page 22. You are looking at something else.
Page 20.
Your selection after 94 was taken note of by the coordinate bench.
Then its order was made.
Then 96 it is this. He says out of that selection, 2 are for UR, 1 for ST. You are saying that you are also corroborating that you are the 4th candidate.
And the select list at page 20.
In fact,
And then the first case.
ଆପଣଙ୍କ ପେପରଟା ଦେଖିବେ or you Mr. Mahanti, you can use the paperless one, but we are looking
I am
at
giving him.
I am on the point of limitation for that reason I am
The division bench might have been arguably an order. It may not be that good order. Somebody may say against our orders also same thing. There is scope for improvement even in heaven. Is it not? The better order could have been written still better. That is always possible.
Order was passed.
1 second.
Division bench.
We have seen that order. We are conversant with such matters. More conversant with such matters because every day we operate such matters. Now we are telling you. The division bench said the relief granted to you by the division bench is dependent upon availability of a regular vacancy.
I was that selection was made for temporary appointment. It is admitted. And I was appointed in the year 2000, subsequent after filing 3 contempt applications.
Mr. Mahanti, we are not deciding the matter or hearing it even.
It requires consideration.
It requires consideration that my lord is telling you, so you gather your thoughts. So straight away don't argue so that the matter gets either way decided. You gather your thoughts regarding this.
Now, after 15 years of the judgment, they appointed me in the on ad hoc basis. The interview was made 94
they appointed me in the year 2009. And thereafter, other two candidates who were appointed in the 2009, in the year 2009, their service was regularized just after 6 years of their service in the year 2015.
Because they belong to reserved category.
Yes. And in merit they are higher also.
They have not mentioned that I am belongs to general category.
No, you should say that. They need not mention.
Mr. Mahanti, perhaps that is the reason the 96 order after selection of 94. The select list is usually valid for a year. But by this order, the select list has been perpetuated for now it is 30 years. And so please wait. What do you want? Do you want we'll allow the writ petition right now or writ appeal?
So we'll admit this. We'll consider slowly.
I am just submitting the findings of the.
We have heard you. Now you assert
Submitting the findings of the Honorable Singh Judge.
You asserted that they should have said that you are not the reserved category. That is not the law. See that Madhuri Patil versus State of Maharashtra, 95 Supreme Court. 95 Supreme Court. It says one who asserts his social status for the benefit of admission or to gain employment, he should prove it that he belongs to that particular business. That's the law. That's how Apex Court has treated. And therefore, matter requires consideration. We'll fix some date. That day we will very coolly we will conduct the case. But matter is made out, admission case is made out for admission.
That is my service.
Already our application in condonation of the appeal is filed after broking a delay of so many days, and our application supported by an affidavit accompanies the appeal. First off, delay is short and explanation offered is plausible. First off, that apart, there are some arguable points in the appeal which weigh in favor of the appellate university. First, in the above circumstances, application is favored and delay is condoned. First, next, having heard learned counsel appearing, learned panel counsel appearing for the appellant university, and also the learned counsel appearing for the contesting respondent employee, come up aware of the considered view that a case is made out for admission, and therefore appeal is admitted for consideration. Interim order. Have you sought for interim order?
Yes, because there is
interim order suspending the operation of impugned judgment is also accorded. Till next date of hearing, file this matter in the 3rd week of August 2025.
The date we fixed, otherwise
Then we'll fix it. 3rd week of August. 3rd week of August. Yes.
you will retire in the meantime.
That. Next.
Item 18.
May I please, Your Lordship?
Yes.
Challenging
Yes.
And there is a delay of around 4 months.
4 months delay.
125 days.
133 days.
133 days.
Around 4 months, 133 days.
Sir.
The matter is relating to revision of pension of the respondent in accordance with the provision of ORSP Rule 2008. And he has retired from the post of MPWS supervisor.
Say the full forms. What is the revised scale of pay rules?
2008.
Multi-purpose health worker.
Multiple health.
Which
This is item. Which item?
I do not know this is
26. 26. 20. Now, read April 27.
Sir, kindly fix up a date for filing counter.
opposite party who appears for the
State is the
state will delay, condone delay. But you should not seek the reciprocity in some other fashion.
No, because I am for the state.
The respondent is at
I am for the state.
Appeal is preferred. You are the employee.
I am the employee.
It's a very long judgment.
Respondent employee after with a delay of 137 days. First of an application supported by the affidavit accompanies the appeal memo. First off, the plausible explanation is offered for the delay proof. First off, there are arguable points on merits of the main matter as well. First off, not condoning delay would eventually result into dismissal of the appeal, and thus it may cause injustice to the appellant, which we cannot do at the court of law. First, next, in the above circumstances, application is favored and delay is cut off. But what this matter in the last week of August 2025 for admission.
The respondent is at the age of 88 years.
88.
So kindly,
In the first week of August 2020. Correct.
I can continue. Let the petitioner in this writ application challenges the order passed by Annexure 12. By this order, the district judge has rejected the prayer of the petitioner to count his service from 2004. The fact is like this: the petitioner was initially engaged as enrolled as a candidate peon. Thereafter, he was appointed as orderly peon in 2004. That is.
No, we are not getting the point at all.
The short point which arises in this case is whether the period between the initial appointment and the reappointment should be treated as break and should be treated as a continuous service.
For what purpose?
For the purpose of counting qualifying service and pension, all these things.
Which period it is?
That kindly turn to page 18. Page 18, Annexure 3. This is the appointment order of the petitioner.
This is the appointment order.
Yes, my lord.
27/4/2004.
Yes, my lord. At page, serial number 7, page 19.
It was removed as for Supreme Court's order.
My lord?
Supreme Court stopped appointment of candidate peons or something happened.
No, my lord, not that. Still it is going on, my lord. As per GRCO. The fact is that he was enrolled as...
Why there is a break of employment?
Lord,
what is the reason of that?
My lord, he was appointed on 27/4/2004, continued for 1 year.
Why it was a break?
This break, that ORB, while appointing the petitioner, ORB Act and rule was not followed.
Was his selection set aside?
No.
There was a break. By not following ORB Act, which is mandatory, what is the Reservation of Vacancy Act?
Yes, my lord. After that, he was reverted.
Reverted in the sense?
Reverted
to the lower post.
But there is no lower post. Candidate peon post, candidate peon is enrolled.
All right.
They perform duty.
One second. He was appointed on 24/7/2004.
From the post of candidate peon, he was enrolled as a candidate peon in 2001. Continued for about 3 years. Thereafter, he was appointed as orderly peon. In 27/4/2004, Annexure 3, page 18.
His first appointment was on which date?
His first appointment was on 3/10/2001.
3/10/2001.
Annexure 2 as page 17 as a candidate peon.
As peon.
Candidate peon.
What is meant by candidate?
Candidate peon is correct, sir. Candidate word is used, I don't know exactly what. So.
Is that post like candidate peon?
Yes, candidate peon. It is provided in the GRCO.
Which page you are asking us to look into?
Page 17.
Selected from the post from candidate to you are hereby directed to report your joining immediately in the office of the undersigned. Civil Judge, Senior Division.
Yes, ma'am.
You are appointed as candidate peon.
Yes, ma'am.
You have been appointed peon, perhaps it is.
3/10/2001.
Whether in your service rules, OJS, Orissa Judicial Officers Rules,
No, ma'am.
2007.
That is in GRCO, in the GRCO.
GRCO.
General Rule and Circular Orders issued by the Honorable High Court.
So candidate, he was appointed as candidate peon.
It must not, that cannot be said to be appointment.
Selection.
Enrolled as a candidate peon. He joined.
Huh?
He reported to duty after being appointed as candidate peon.
He appointed on which date?
3/10/2001, my lord.
That's not an appointment order, sir.
It's a selection report. Report you were joining immediately.
You have been selected for the post of candidate peon. You are hereby directed to report your joining immediately in the office of
All
the.
right. When you reported for duty?
Not just. 3/10/2001.
Huh?
Any joining or
Where
joining
is the
report?
joining report?
Joining report you filed.
There is an admitted case, my lord.
Admitted case.
Admitted case.
Who has admitted?
In the counter of affidavit also admitted.
They have
They admit that you joined on so
same day you joined.
You admit that.
My lord, one thing is that there are three opposite parties. He was appointed, enrolled as a candidate peon by opposite party number 1, appointed as a orderly peon by.
We are not disbelieving that. We simply asked you, did you file a joining report? Your answer is no or yes.
That I have to take instruction, but yes,
Anyway, let me ask this person. Brother, what did he say? He reported for duty on which date?
That is not in also in the counter, my lord.
In your counter you have stated.
This is also page 4 of my counter, filed by page 4 of my counter, filed by opposite partner 2 and 3. Paragraph 9, my lord.
Page 49. Scroll to page 49.
Internal page 4 of the counter.
Yes, my consider upon his enrollment, he was selected for the candidate peon on under further he was selected in the post of peon. That not given the date of joining.
What is that order dated 27/4/2004? You were removed from service.
27/4/2004, I was appointed as orderly peon, regular orderly peon.
Without following the wire act, my lord. And for that reason, he has reverted to the post, his initial post, my lord. That is the candidate peon, my lord.
Without following procedure means what? For peon, what is there? Is there any selection like interview, other things for peon? What is that? You are saying he was not
person registered in a pool for future substantive post, for appointment of future substantive post. That is candidate peon.
So that is candidate.
That is decided.
That is not appointment letter at all.
That is the case law in 2009. Santosh Kumar, Justice B.S. Chauhan.
Okay, but the order says you report for duty immediately.
That is
Order.
that is in fact no appointment. Candidate peon no appointment. Just
Temporary status.
he has been engaged for the future substantive post.
The candidate peon means.
Yes.
But when the order says you report for duty immediately, and he says that I reported for duty also, where have you denied that?
No appointment, no. Substantive post, pool for a substantive.
In the appointment order also it is mentioned, candidate peon of civil court Nijarad Burger is appointed temporarily as a class 4 employee.
He is not appointing authority.
But appointing authority is opposite party number 1.
He is the appointing authority.
Yes, my lord.
Under which?
Discharge is the appointing authority.
No. Sir, you are not. See the technical code.
Yes, my lord.
The person who issued the order is not the appointing authority. You are saying yes. Then you are saying district.
No, my lord. Enrollment as a candidate peon.
Appointing authority, sir. Appointing authority.
My lord, the appointment order, my kindly is in the initial appointment as candidate peon, page 16.
You are top of your brief to know everything, but still then you have to discuss. You must understand.
Yes, madam.
You are not that as
Appointing select authority for selecting candidate peon is the law discharge. Yes, madam. Discharge is the competent authority. Yes, my lord. What is the office of the district judge of Simpur? This is written by the registered civil court. Sambalpur.
So he acts on behalf of the district.
Yes, my lord. What he writes, I am directed to inform that the district of Sambalpur has been pleased to approve the enrollment of Sri Baleswar Sahu, Jituranjan Mahanti and Surendra Kumar Sahu as a candidate peon. Jituranjan Mahanti is the petitioner. Thereafter, consequential order was issued by the Civil Judge Senior Division.
But we thought you were removed the contribute or they reverted.
Yes, my lord. I am showing that. That is page 26, annexure 5. May I place it?
5.
Yes, my lord.
26.
The person order was passed by the Lord District.
That was double challenge.
Yes, reversion was challenged. Reversion was challenged in a writ petition by virtue of an interim order.
What happened with the
My writ petition after his appointment in 2007, the writ petition was withdrawn.
challenge to the 25% order?
Yes, ma'am. Yes, ma'am.
But the repetition, you are sure?
Yes, I have mentioned that.
No. I am not asking whether you are mentioned. So that repetition you have withdrawn.
Yes. After he was reappointed, the writ petition was withdrawn.
Where is the reappointment order?
That is that is in 2007. It starts from page 29, annexure 7. The issued by the laundry seals of Sambalpur.
What he said was it?
Yes, my lord.
Service through.
Yes, my lord.
That period has to be counted for just qualifying services. Sensible.
Lord, that the previous appointment in the regular establishment, that is a wrong appointment order, my lord. Without thereafter, another selection came, my lord. That is a trace selection, not that previous reversion order was challenged, and without being set aside and without this honorable court.
He had filed the order, challenged the reversion order dated 13/2005. WP number.
Well, that was
Yes,
withdrawn,
ma'am.
my lord.
Of the stay. WP number?
No, my lord, there was no stay.
There was no stay.
No stay. But no, my lord. Thereafter, interim order was passed. I have quoted the interim order at page 7 of the writ petition.
WP number?
6733 of 2005.
2005.
Yes, my lord.
Well, interim order is made on
Interim order is made on 18/4/2007.
saying
I have quoted, my lord. I am just placing that
where is that?
at page 7 of the writ petition. You have got it? Had learned counsel for the parties from Annexure 5 to the Miss case, we find that though 5 number of class 4 posts are lying vacant in the Justice of Sambalpur and all are process server posts, as the matter is sub judice before this court in so and so, including the present writ petition, the said posts are not being filled up. As an interim measure, we direct that pendency of the above writ petition will not be a bar on the part of the authority to fill up the said class 4 posts of process servers observing the provisions of the ORB rules.
What is
Yes, my lord.
Now we go to see what should happen to the beginning of service during this period.
That should be condoned because it is less than 2 years as per the government circular.
You participate in the subsequent application process.
No, candidate peons are not allowed to participate, only
See, there is a subsequent selection.
no, my lord, there is no subsequent selection. All the
My lord, I have stated in the para 9 of my counter, my lord, that it is not but internal page 5. My lord. Page 4 of the cassette counter, my lord. That it is not disputed that the petition was enrolled. My lord, my lord, my lord, my lord.
In your counter, where you are getting with this subsequent appointment, which part? Where you
Say para 9.
before that. Para 4 should be.
they have said it is.
Yes, my lord.
They have said it is for the OP number 1 to say.
That para 4, that in response to para 1 of the writ petition, it is humbly submitted that the petition has not challenged the order number 48 dated 13/5/2005.
No.
Of the district judge Sambalpur, opposite party number 1, when he was reverted back from the post of orderly peon of the court of CJM Bargarh to candidate peon and joined as candidate peon in the district judge Nijarat office Sambalpur on dated 23/5/2005. Thereafter, as per order number 61 dated 7/5/2007, valid serial number 8, the petitioner was appointed temporarily as order peon and posted as such in the court of the additional district judge Jharsuguda. Accordingly, on dated 9/5/2007, the petitioner joined as orderly peon in the court of the ADJ Jharsuguda and his service book was opened as per the Government of Orissa Finance Department notification number such and such dated 17/9/2005. A person who appointed on or after 1/1/2005 in the government service, he shall govern under OCS Pension Amendment Rule 2005. The NPS is being deducted from the salary of the petitioner as per cited notification as the petitioner joined government service on 9/5/2007. The service cannot be counted as a continuous service from 13/5/2005 to 8/5/2007 as he has reverted back to the post of candidate peon on 13/5/2005, my lord.
That you are reversed. Second, the petition.
No, my lord.
You withdraw the petition.
Yes, but because they have.
Remained as it is.
Yes, my lord.
Withdraw because of the fine.
Yes.
Correct.
Yes.
But the reversion order remains seated.
Yes, my lord.
But
Let of 1992 shooting.
yes, my lord, that I admit.
Since he withdrew that reversion order remains intact. And the other aspect is of task.
Yes, my lord.
That suppose candidate peon is continuing as a candidate peon.
Yes.
Does that period as candidate peon is a pensionable service?
No.
Not pensionable.
I want. Yes, my lord.
I don't have explanation. It's not there.
Yes.
The answer is no.
Yes.
So suppose he is a regular peon, orderly peon.
Yes.
That counts as a pensionable service. Yes.
Yes.
So there, suppose you continue as a candidate peon for say 15 you at an age of superannuation. You will be entitled for
No.
pension.
My prayer is.
No. I can answer. It's not against him. It is easy to understand your proposition. You were designated as a candidate peon or as a regular peon?
This
What takes back?
as a
You continued as a candidate peon, that is how you have become eligible to become subsequently as a
yes,
orderly peon.
yes, my lord.
That you can take it from 8/5/2005.
Yes, my lord. But my lord,
13/5/2005, that is during the period between 13/5/2005 and 8/5/2007.
Yes, madam. My prayer is that period may be treated as a break, and maybe my service may be treated as a continuous. Why I pray so? But after my first appointment, my service book was opened, my GIS was deducted, my GPF account was also opened. GPF,
But that was set aside.
no, that is only I was reverted.
Problem is that whenever you get appointment, this is happened.
Yes, ma'am.
But does that ensure to the benefit that irregular appointment become regular?
No, man, I don't say that. I only say whether my appointment. Yes.
Application has that order to them set aside. This is too late in the day. After that, again, you maybe you update it rightly.
Yes.
Because otherwise, you would have lost that opportunity of reengagement also. Suppose you have contested that.
Yes, ma'am.
Would have stopped there. If you make full payment of salary and other things from the same thing, then he served.
So, my lord, may I submit something in that case? I have not want to candidate peon.
Who are you?
Well, I was just from because that candidate peon is the one. No, I am not in this case. I am just well, candidate peon is not any post. That is a pool, and their credibility is to yes. That is the only selection process, and they don't get a single pie. That's why this honorable court has struck down that process of candidate peon 10 years, 15 years without any salary. That's why, my lord, this is not pensionable, nothing. That is only that credibility has to be established.
No remuneration also. No remuneration. These are duty like regular employees, but don't get any remuneration.
Yes.
Yes, but we are asked.
Being in the pool itself.
Yes, my lord.
Does not create the employer-employee relationship.
No, absolutely right.
Gives eligibility like that I'm asking you.
Yes.
Suppose you wish to come back to go back to the pool, you remain in the pool.
Yes, ma'am.
Till you are made appointment, you are given appointment. That is so that I was asking. There is nothing location.
My lord, one back.
Come back.
Well, just a small pair. In this case, opposite party number 1 has not filed counter affidavit. Because he is the appointing authority, reverting authority, and reappointing authority. So, why such a man let it be taken upon someday? So, I have some personal difficulty too. Let it be on Monday, my lord.
Yes.
I got the information of the present address of the applicant.
You should have paragraph 1.
But in my lord, may kindly see paragraph. They are saying this is for of the opposite party number 1 to state. Yes, ma'am.
Who is sitting there? Look at your prospect. I was trying to answer you what you were saying that I thought that
opposite party number 1 is District Sambalpur.
It's a pool. They will be in the pool. They will be drawn whenever
For future vacancy.
Even otherwise.
Maybe Mr. Das, because it was struck down, so you took the right decision not to go behind that order and analyze it.
You have given your petition. You have given up the challenge.
Yes, that I admit, my lord.
Then
but because this authorized also.
You should have.
In service.
No. You should have told the court before withdrawing.
Yes,
sir. So far as my continuation, that relief you should have sought for at the hands of the court. You are restudicated. That your case falls in the doctrine of restudicator, constructive restudicator.
Yes, sir.
He may lose that also.
Everything is gone.
Everything is gone. But nothing can be done in that matter. Anyway, there is nothing. 1 second, just tell me. The short grievance of the petitioner is as to
All of you kindly sit down.
non-counting of his alleged previous service during the period between 13/5/2005 and 8/5/2007. First half. Learned counsel appearing for the petitioner argues that since he has actually served during the said period and that the said service was pursuant to the approval of candidate Pune, wide order dated 3/10/2001 by the district judge himself, denying of that service benefit is unjust and unreasonable. First one. Learned counsel appearing for the AGA appearing for the respondents.
Yes.
That's right.
You are in this.
Yes,
What is additional standing counsel appearing for the opposing parties. Per contra, resist the petition, contending that an irregular service rendered cannot be counted as a regular service, and therefore no relief can be accorded to the petitioner as sought for. First off, next one, having heard the learned counsel for the parties and having perused the petition papers, we broadly agree with the submission made on behalf of the opposite parties, and therefore we decline indulgence in the matter. First off, it has been a settled position of law that when irregular service is rendered, unless it is regularized, the same cannot be counted as part of regular service. First off, rulings in this regard abound. First off, they need not be referred to since the proposition is as clear as Gangetic waters. First off, next one, in the above circumstances, the petition being devoid of merits is liable to be and accordingly rejected. Before that, petitioner had laid his reversion order dated 13/5/2005 in WP number 6733 of 2005, and there was an interim order dated 18/4/2007, whereby the authority were permitted to make regular appointment in accordance with law. First off, accordingly, the petitioner came to be appointed on regular basis. Wide order dated 18/5/2007.
7/5/2007.
Wide order dated 7/5/2007. First off, this appointment petitioner accepted without raising a little finger before the learned single judge, inasmuch as he withdrew the writ petition and thus giving up challenge to the reversion order. This is another paragraph. In the above circumstances, petition is liable to be and is rejected. Okay. Yes.
Item 25.
So that was mentioned by Smith informed the council last year. Item kete number item sir?
Item 23.
Mr. Ranjan Naik.
Ranjan Naik.
23. Inform me. Because he almost gave this slip at 120. Yes.
Item 25.
My lord, I am on behalf of Mr. Bhavan Shankar Raju. Pass over, my lord.
Passover. Today, at this hour,
We have not filed.
already we are 15 minutes.
Last occasion also directed to the government to file counter.
We have not filed counter, lordship. It is urgent to 4-8, my lord.
So he mentioned it to be taken up. Who has mentioned?
No, not mentioned in the
4th of
order.
August. Why it has been lifted?
In the order sheet, my lord, it has reflected 4-8, my lord.
For it,
My lord.
Instead
but
of
why it is posted?
No, we have to give time.
Call this man from 4-8.
4-8.
4-7, sir.
4-7.
4-7 has been be.
Shall we say that instead of 4-8, it has been typed as
My
posted?
lord, my lord.
Okay.
In the status, it is showing my lord 4-8.
Any difficulty if it goes to 4-8? 4th of August kale habo?
Agora urgent है इधर 4-8.
here,
Yes, yes. Reflect the appearance as appears in the curve. Yes, sir. Your name, sir? Apna na ko
my name is Kalan Choda Sahu.
Mr. K. Sahoo on behalf of B.S. Raiguru for the petitioner. Mr. Mandayatra A.C. for the state. S.K. Patra standing counsel for OP 4 and 5.
Item 26.
Yes.
Item 26 on behalf of SS Mahapatra. Kindly taken up Monday.
First week of August.
So you have appeared after service of notice. Received copy.
Yes, my lord. Are you proxy?
Notice has been issued since my lord.
Not looking at the brief. It is your chamber or you are a proxy counsel? ଆପଣଙ୍କର chamber brief ଏଇଟା? You should look at ଆପଣ ଦେଖିକି ଆସିବା କଥା କ'ଣ order ହେଇଥିଲା, what was the order last date, why it has been listed. That is how one starts getting into the process of arguing and
Learning.
8/10/2024 notice was issued.
as date for by the respondent list date given 5/8.
Item 27.
27. That's great, my lord.
Yes.
Kindly taken up 2 weeks after, ma'am.
For the appellant 4 weeks, Mr. Das. You say 4 weeks.
2 weeks.
2 weeks.
My God. I am waiting for a wit fund of 2 and 3. Provident Fund organization. I can say Provident Fund has got no role to play in this repeating. As per his government, Provident Fund doesn't have any role.
But who is for the union appearing? You are also for the appearing?
No.
Union of India?
Union Drive.
2 weeks after, as paid for by the petition. By the appellant, sorry.
My presence mechanism.
Sir, Bimbisar Das for the OP number 2 and 3.
Item 28.
May I please, lords?
Yes.
The appellant.
Sorry, Mr. Mahapatra informed or a court master informed? Mr. Naik, he is aware that or he is not aware of this?
No, he himself has given
He
this.
himself has given this, but left. He might have thought that.
Left.
Four, 5, 6, 7, 8, not yet, sir. Dr. Lekha.
Notice was issued by registered post.
So 4, 5, 6, 7, 8, Mr. Das, you are appearing?
No, I'm appearing. Homeland retired, my lord.
1 and 2, I'm appearing for 1 and 2.
Both notices.
So it's
issued notice. So how
the interstate seniority matter. So other opposite parties,
They have written only, I have petitioner admittedly senior. Appellant is admitted, let me.
that is the merit of the case. Need appeal.
They also did not appear before the single judge. The private respondents notice.
Sir, I'm in 2 and 3. Sir, I'm appearing for 2 and 3. Sorry, madam.
Private respondents.
Gridco.
I'm for the opposite party number 1. Sorry, respondent number 1.
In the meantime, all private opposite party retired on attaining the age of superannuation.
Is that relevant for the sufficiency of notice?
My lord,
There is a
my
High Court ruler CPC that somebody returned, then no notice is to be issued. Then we can pass that on.
Interstate seniority matter. So
they have not appeared before the honorable single judge with respect service of notice. No. If your lordship, it is my lords to decide.
No, now there is an order under which the rights of the parties are concluded. If we want to upset them, then notice has to be.
Notice already issued, my lord.
Yes, issued.
Notice issued, registered post filed, my lord. But as per
Not sufficient.
Most likely, did you take notice in official address? Office address you took or the residential address?
I took residential address, those who have retired and those are continuing at the relevant time in the official address.
So better instead of waiting, you should take fresh notice so that we can save time. Every time it will be listed, this issue will crop up. OP 4 to 9 not served. And as very correctly pointed by my esteemed senior that the writ petition is in their favor. So it's a competing claim, right?
Right, some conclusion.
So we never know. For that reason, unnecessarily, you will be dragged into more litigation.
interstate seniority matter. That is why.
But all they are retired now.
All the retired.
If they are retired, whether seniority will alter their status, except ranking, whether terminal benefits, demotion.
My claim only at par with the juniors, promotion and seniority are par with the juniors.
Suppose somebody is asked to give way to you as the last candidate. He will be impacted. Is there a possibility? That was the query from my lord.
Unless what Apex Court said is, ordinarily in seniority disputes, the others who will be likely to be affected should be made parties.
Parties made, notice was issued by registered post.
We are saying that.
We will give lordship, we give some more time.
I have not completed my speech. Ordinarily, any standard books, there are judgments also. Those who are likely to be affected by the rankings, in the event we issue writ in your matter,
Your lordship is right.
they need to be made parties, number one. Number two, there are two exceptions to this. One of them is, if they have already retired by the time matter comes in appeal before this court, and our granting relief to you will not alter their status.
I am not saying alter. I am not praying also alter.
It will not alter also.
Only at par with the juniors.
You file a memo seeking dispensing with notice to those people. We'll make observation so that we can.
Already, my lord, notice has been issued.
Issued. You want to
notice
take
issued by registered post.
That's all we have understood. Therefore, now we are saying something in your favor.
My lord.
Unless you are able to catch it, unless you raise your antenna to some higher level,
We will also give you another date so that I press.
we'll take steps for that.
Press notice.
The
In the correct address.
You
your
can
lordship.
file a memo for the timing that
In the correct address so that
you are not pressing for notice.
Notice that's for me. Memorial.
You have to file that memo that will
we
be
can dispense with the notice only.
dispense with.
My lord, I'll file memo.
The notice will be applicable. Not
I'll
claiming.
file memo. I'll file
Give
memo.
him a paper. कागज तो दियो.
Learned counsel appearing for the appellant has filed a memo and also submits that the private respondents to whom notices have remained unserved are not necessary parties in as much as they, having attained the age of superannuation, have demitted the offices, and that even by allowing the writ petition, they would not be in any way prejudiced. First of all. Therefore, he seeks dispensing with notice, court notice to those respondents. First, we agree with this. Next paragraph. In view of the above, notice to unserved respondents need not be freshly issued at all. When do you want, brother?
Next week, Lords.
Next week we have difficulty. Many matters we have posted already. We'll have it in the second week of August.
If second week of August, then I will take press notice, my lord. If delay will be, my lord.
I'll recall that.
My lord, delay, if it will be delay, then I will take press notice.
He should take the press notice.
Petitioner, the appellant is granted a period of 1 week for taking fresh steps in respect of unserved opposite parties. First of all, requisites to be furnished. Responses. Responses.
May I pray in the correct address since they have
Whatever you discover, there we can't adjudicate that which is the
correct notice to correct in the correct address.
whatever, sir, no difficulty. Present correct address you are, we will be happy.
Very well.
If you write that memo, nobody will object then.
Yes.
You call that Passover?
Promotion is concerned. Suppose they may say otherwise. Package is not there.
That risk is. That
was the query to you. Suppose somebody will be going to you, then Passover matter at 23.
Other things will remain.
You can also have passed this order in absence of the other side.
Just inform him.
The earlier order remains unchanged. It is only added.
My lord.
Yes.
My lords, on behalf of State Bank of India, my lords, I've just served a copy of the counter on my learned friend.
Right now.
Yes, my lords, I called up the council, but he is in Bhubaneswar, so
Anyway, the counter is received by me right now. My lordship, this case was admitted.
So you want to go to the
I'm from the appellant.
correct, sir. You want to go to the counter?
This counter?
Whatever is
Whichever you have received.
Yes,
now,
yes.
Do you want to read it or not?
Yes.
Then
For
we'll
this I
give you
will take time. For this I will take time. But that is an IF match.
He also.
Yes. There is an interim application. The application was heard on 7th of January 2025.
Is there any order?
Yes. The order was like that they may proceed for auction, but they cannot publish the result without the leave of
7/1/25 order.
without the leave of this court. Yes.
7/1/25 order.
7/1/25.
7 January
7 January.
25 order.
Yeah, but
That order should be continued.
no, sir.
Huh?
Now things have been changed. That date was posted to 18th of February, but it did not come up.
No, what you want now?
Now I want that this possession of the houses, both the houses, the two buildings are there. Now they have already taken the money, adjusted everything. Now impose of penalty, you can see my lord, you can see the notice.
No,
It's
kindly,
the-
sir, don't veer off the track.
Sir.
Look at the order dated, order number 1 dated 7/1/2025.
Yeah.
You want variance of that order.
No, I want to stop the proceedings under Surface Act.
How can it be?
Already we have paid,
said.
sir. The matter is there. Already we have paid. There is a compromise. We have paid the compromise amount.
The order doesn't reflect.
No, that order
anything.
No, it was just admitted. Now this petition also exposes everything. This petition, they have told that the only amount of 23 lakhs as against a valuation of 87 lakhs. They have come down for an auction sale. That is annexed to 2.
My lords, the matter may be posted to a day when we can argue it finally.
No, sir, unless I get this relief, I have to pay every month watch and ward charges.
So we'll have this matter next week itself so that we can hear and dispose.
Any date after 17th, my lords? I am
After 17th.
My lords,
No.
It is.
Sir, what to take a
my
decision on
lords,
this IA?
going out of station to admit my child into the hospital.
Always, sir, you want a order, whatever was passed at your instance. Now you want variance of that order without any
No, I have
circumstances.
this IA, I have filed afterwards. After 7.
Fair enough. But that substantially changes the earlier order. That cannot be done in the interim stage.
We can hear the main matter itself
Give
shortly
copy of this, I
and dispose of.
And so a copy on the.
That copy of the IA may be given to me. If there is another.
In the meanwhile, you give copy of that
No,
matter.
sir, my very seriousness is only one thing, sir. The father and son, both are guarantors. Father is having a building which is under collateral. Son is also having a building which is also in collateral. Now the father is 90 years of age old. He is crying every
1
day.
week, will he become 91?
Sir?
1 week.
1 week. Okay.
Well, next week only we'll hear that.
Okay.
Next week.
My lords, any day after 16th, my lords, I'm not in town. My lords, I have to admit my child to the hostel.
Okay.
I'm out of station for 4-5 days, my lords. I'm not there from 10 to 15.
10
So
to
it may-
15 you are not there.
There, my lords. So
16th you are coming back.
I'm back. My
On
lords.
16th we will have this.
My lords, one day to prepare.
17th will. That day you should not seek time.
No, my lords.
Because he has moved the application.
I will not seek time, my lords.
Call this matter on 17th at the request of standing counsel for the respondent bank. Finally.
That is which IA? Number?
My lords, let them give me a copy.
Give copy in the meanwhile. One more copy.
You know the number?
What number?
IA number.
IA number.
Yes, 595.
Please give a copy. And like, my lords, I think we should be allowed service through email. Otherwise, we are finding it difficult to like this.
You share your email ID with your Ladet colleague.
Yes.
Obligements.
Justice Noel of last judgment says.
Item 30.
Push to make it.
Regender appeal to file by the.
You want to go through?
Yes, one judgment has been cited.
Okay. Which date you want?
Regender, I have sought to them.
He wants to go through the rejoinder.
Well, that's only the judgments of this court, my lord, this honorable court.
Which date you want, brother?
Chapter 16.
After?
16 column.
On the 18th you shall have? Yes. Call on 18th at the request of learned AGA.
That will take 6 minutes.
To the post of member, Odisha Consumer Commission, Odisha State Consumer Commission. Even though
405
even the opposite party number 4 ineligible, she was appointed and continued last 3 years, 3 and 3 months. Only 7 months, 8 months is after 7 and 8 months term will over, the writ petition will be infructuous. And the respondent counsel who appeared, last 2 occasions he did not appear.
The appearing from that lady. This is the overrun.
No, my lord.
You want to be appointed?
Now, I am challenging the order of Honorable Single Judge. The Honorable Single Judge misinterpreting the rule wrongly held that respondent for eligible.
What kind of removal and
For passing up appointment of respondent 4 and 5 on the ground of his ineligibility and to appoint, since petitioner was selected after written and viva, appellant was selected after written and viva, she should be appointed in place of respondent 4.
So it is a certiorari coupled with over and do coupled with madams. Correct.
My lordship right.
Which is the famous judgment, Professor, on that? The famous judgment of Karnataka in Supreme Court. G.K. Govinda was state of Mysore, state of Tangent. They have laid down the parameters on this. Any standard on law. This is the case of operation of this statement.
Miller?
Sahoo.
The base.
It has followed Govinda. G.K. Govinda. And you take up that G.K. Govinda, just look into that. There are some instances. The learned single is not good. Which year? Anybody Google of that judgment? Court can put any questions to anyone in the court. Also, there is no restriction came. You know, it's people have legal energy. Court can put any question to anybody in the court. There is a section in evidence.
G.K. Govinda Rao versus State of Karnataka on 9 March 2011.
Very good, but it might have been another case. It may be. It cannot be State of Karnataka because at that time, State of Karnataka was not there. It had to give Mysore. So it was G.K. Govinda versus Mysore University. CD going. Your University of Mysore is CD going.
That is
They are 65 years.
that is coherent. That is related to coherent of.
Coherent coupled with the
Coupled.
sectional
My lord, my lord.
Your this subject is not law.
My lord.
This subject is not law or law.
Not law. Before joining, I registered.
Youngsters, there are good things. You should go on making the rules. When lawyers go to the rulings, courts, judges go to rulings and rules.
In that G. Govinda Rao case, the appeals court held that
Sahoo, his memory is tremendous. He has all notes. Whenever we discuss one matter, immediately he will take out that. Yes.
in that judgment, the appeals court held that this is ineligible. Under what authority you have
Holding the
holding
post.
the
in
post?
question. Your friend had,
But
you are not ready.
Hope that they will not appear or what? They are not registered.
My lord, last occasion, when this honorable court to proceed, my lord, senior Mr. Buddhadeva Rautura appearing for the respondent.
If he is retiring within 3 months, brother, 3 months, then
7 months.
it should become infectious. Of course,
After 7 months, he will retire.
7 months.
No.
It will not become infectious because he has a claim to that post.
Yes, madam.
You are appointed ineligible person.
See the ineligible holding the post last 3.5 years.
And what will happen to the orders passed by him?
The recruitment has been made in the year 2022, madam.
Maybe
That's all right. Even one day, an eligible candidate cannot continue in the post, even for one day. That's what the GK, that Govind Rao said.
So many judgments.
CD Govind Rao. All right. To enable counsel for the appellant solve this matter in the 3rd week of July 2025. July.
April 2nd week, man.
Second week, we have already posted matters. Otherwise, we would have posted it.
May I pray, Your Lordship, keep it till 3rd week. I have no objection. Since this is urgent matter, 2 p.m., Your Lordship.
2 p.m.
My lord.
Suppose if we take it at 12:30 only,
No problem.
therefore let it be like that. The third, some date maybe to enable counsel for the contesting respondent.
May I pray one thing?
Yes.
In between the notice, fresh notice may be issued to the respondent of 4.
No
notice, only just for his, because he never appear, my lord. His counsel never appear, or counsel never appear before this honorable court.
No, next date if he does not come,
that may be recorded. That may be
registry to speak to learned counsel about the date of next date of hearing, over phone. You also send message.
My lord.
Okay.
Today I informed me.
You are informed.
Today I informed he told me he will not appear.
But you think that his case is very strong and court will look after his interest. Yes.
Item 39.
Yeah.
And the wife is the appellant here.
Wife's appeal.
Wife's appellant. Against the order of family court granting divorce and permanent alimony. The divorce application was filed by the husband, the respondent here. The learned family court has allowed the divorce application and granted permanent alimony of 5 lakhs rupees.
5 lakhs.
5 lakhs, madam.
What the husband is and what the wife is.
Wife has a +2 commerce.
+2
commerce. And
12. Okay.
12th commerce, and she doesn't have any job, mind. She's residing with her parents, my lord. On the other hand, the respondent has admitted in his cross-examination by the father of the respondent has admitted that he's an insurance agent, and at the time of marriage, he was working in Bhushan Steel Plant.
Yes, brother. Yes, madam.
May I please?
Yes, sir.
Here, the order passed by the Honorable Single Judge is under challenge, madam.
Why you were before the single judge?
Yes, madam. Annex 25, madam, page 292, madam. Yep.
292.
Yes, madam.
What was your representation dated 4/7/2016? Grant of promotion. You had sought for promotion.
Yes, madam. They have sought for promotion, madam.
From which post to which post?
Well, they claim, my lord, from technician B to technician C, madam.
Is submitted with the institute.
Yes, madam.
Employer.
Yes.
Employer.
I'm appealing for the Niger, my lord. Well, last time I turn to page 302, my lord. 7.3. May I place, my lord?
Let us say. Just put there.
Yes, 302.
Yes, my lord. Last paragraph.
In view of the illegalities committed.
In view of such illegalities committed by the authorities of Niger, this court, while disposing the writ petition,
Redesignate the petitioners.
What?
Redesignate the
Yes,
petitioner.
redesignate the petitioner as clerk A/LDC from the time similar redesignation was made in respect of group as technician B. This court further direct the opposite party Niger to extend the benefit of promotion to the present petitioners to the rank of clerk B/UDC from the date similarly situated person operator laboratory function technician got benefit of promotion to the rank of technician C with all consequential service benefits. Now this order was passed, my lord, which was neither in the pleading nor in the prayer.
What was the prayer in the?
Yes, read application.
Representation.
Now, my lord,
The prayer in the
yes, madam. And now your lordship may turn to page 238, madam.
So that's look at para 7. There is a finding.
Yes.
The finding given.
Yes,
I think hard nodded counsel. This is internal page 7 of that judgment.
yes,
301.
yes, 301. Having heard the learned counsel for the parties and after going through the materials available on record, this court finds that basing on a common advertisement issued by Niger on 31/3/2012 or Annex 3, petitioners are made their applications against post of operator general function in the office order issued on December.
Read slowly there.
Madam?
That's important because that's a finding. Just kindly go slow.
Yes, madam. Operator general function in the office order issued on December 2, 2013 by the Annex 2 series, all the selectees were appointed as against post of operator, and in the said order, nothing was indicated as to who were appointed as operator laboratory function and operator general function.
Is it correct?
That is correct.
No, madam, the applications were submitted by the petitioners claiming that they would want operator general functions.
No.
All the applicants.
Madam?
All the applicants.
All the applicants. madam.
All right.
Read that portion.
Yes,
It is not indicated.
yes.
That finding is correct or wrong?
How you have structured your appeal?
All the selectees were appointed as against the post of operator and in
General.
the said order.
Yes.
The general word is not there.
Huh?
Post of operator it only says. Sir.
Operator laboratory function.
And
Operator laboratory function and operator general function. But basing on the
After finding that there is no such distinction, it is only operator.
in the advertisement, my lord, there was distinction was made operator general function and operator laboratory function.
But while preparing the select list,
Select list, my lord.
you had
In December 2013.
Yes,
So only
Right.
operator is mentioned.
operator general function and operator.
One second, let us, if
My
we
lord,
can make
basing on the qualification, my lord.
let him show the
My lord,
select.
general function means
No, that's all right.
Yes.
Show the select list.
yes. No, no, my lord, there lost see thereafter, my lord.
Where is the select list? We have read it now. Courts have said,
Select list, my lord.
select.
Select
In the
list is
select
not the
list,
next, my lord. Here.
you have said,
Yes.
will take effect.
My lord, dear last see the Annex 2, my lord.
No, we are not saying. We are asking you to show us the select list.
My lord, select list is in the REIT. They have not annexed it.
That was not annexed, my lord.
My lord, it is in the REIT. REIT is also.
Read, we are having. He may not be having.
My lord, mo pakhare hoche.
Read annex of page.
Page 42.
Go to page 42.
The repetition.
Yes, my lord.
Select list will tell. You might have called so many class of employees, but the question is, in the select list, this is what Justice Ramajoyce writes in his services under the state. Select list. Based upon select list, seniority list is prepared. Based upon seniority, promotion cases are considered for promotion.
Here is a case, my lord.
Here is a show us first select list.
Yes, sir.
Select list is very important document. It's like jugular vein of this case.
There. That was not there.
Look at 42.
42. Sure.
Yes.
How you appointed all these people and to against which positions. No, this is probation.
No, this is not select list.
Select list. Where is the selection? Select list.
This is after completion of probation, my lord.
That's what. Therefore, we want to know select list.
Yes. That select list I have not annexed, my lord.
That is very important.
Yes, that I. No, I want to say, my lord, because annexure 2 will clarify this, because annexure last week on to annexure 2, my lord. Page 34, my lord.
34.
This is the application of the petitioner, my lord. Before that, my lord, I want to draw your lordship's attention to page 29, my lord.
34.
Yes, 34. So before that, my lord, 29, my lordship, see for a moment, my lord.
30?
29.
29.
Yes. Post code 05. Operator.
Laboratory function.
For laboratory function, 7 post. Essential qualification. 2. For general function, 9 post. Essential qualifications.
This is your recruitment notification.
Yes.
That's all right. They applied against which post?
Yes. Annexure page 34, man. Post code 05, post applied for operator, general function.
Operator general function.
Yes. Along with
one set of one employee is operator general function.
Yes.
Another class of employees is
operator laboratory functions. Qualifications is.
And the redesignation happened with whom? Operator.
There are 2 rules, my lord. One for scientific people and other for administrative people. These general functions, they come within the purview of administrative functions. And operators C and D, they come within the purview of scientific.
So this person applied
for qualification there.
1 second. This person at annexure 2,
yes,
34.
Yes.
He had staked his claim for appointment as
operator general function.
Operator general.
Yes.
Whether qualifications are same for both?
No.
Different.
Science.
Separate qualification. Because for scientific people, for administrative people.
Then 38.
Just take us through the qualification.
Yes, qualification.
Page 29.
Yes. Page 29.
It is bachelor's degree in science, BSc, chemistry, biology, or mathematics are the major subject.
Minimum 1 year experience
in faculties, in research scholars in a chemistry laboratory, chemistry, biology, maths laboratory.
Then in for general function,
bachelor's degree in science,
commerce with
at least 1 year working experience in the areas of administration and establishment.
So
finance,
two different posts only.
Yes.
And which posts were redesignated?
The scientific post were redesignated.
Not administrative.
No.
So the learned single judge treated this post and that post as equivalent. This appears to be. You see, 2000 recruitment is 1 second. Just
Yes, ma'am. Yes, ma'am.
recruitment application notification says two classes of fee. Notification says two different educational qualifications. One is on the administrative side, another is on the technical side, scientific technical side, technology side. If redesignation of persons in the technical side happens, how can that be equated to these people? Your claims.
My lord. My lord, my submission before your lordship.
Finding that paragraph
Yes, my lord.
7.
Yes, my lord.
That appears to be correct.
Absolutely.
Yes, my lord. My lord, my
And just again, this since we are going to page 29, look at page 29 again. Just now you also placed that.
Two gross mistakes occur from the impugned order. Number one, treating administrative staff as technical staff and therefore directing redesignation. This is first foundation of the wrong. Number two, learned single judge directs the promotion of these people on the basis of that equalization. In 74 Supreme Court, you have seen.
my lord, may I submit?
Look at that.
Yes, my lord. That is while disposing the writ petition.
No.
Yes.
29, page 29.
How you have entered, that's important.
Your
Page
application
29.
itself is different.
Written as the written. So all the annexes are there in the writ appeal also, but maybe differently is marked.
This is sufficient. This shows.
29. One.
Next one.
Yes, my lord.
The asterisk below the post code 5.
Yes, my lord.
For post code 5.
Yes, my lord.
Yes. You
My
were
lord,
given an option.
Our prayer before the writ petition, my lord, in the writ petition, to give us promotion. Because we are appointed as operators. My lord, kindly have a glance too.
No, that's not.
In the writ.
No, your operator says true, but
Yes.
your laboratory function operator in administrative side.
Yes, my lord.
Correct.
My lord, operative side, the one recruitment was conducted.
Correct.
One recruitment process, my lord. One written test for all in one subject, my lord. For all. And the Viva was for different. One administrative expert was there for administrative people since they have chosen that subject. And for the technical subject, another administrative persons were also there. But the recruitment test is one for them. Yes, my lord. Kindly have a glance to that advertisement.
We can't ignore what Mr. Samaraditya Pal says.
Yes, my lord.
While interpreting which post the persons are appointed, you cannot ignore the recruitment notification, prescribed qualifications,
Yes.
pay scales,
Yes, my lord.
and such other things.
My lord, the pay scale are same.
To you,
And the register, who is the appointing authority for both these
Are same.
two sets of persons are same.
Same.
One single recruitment test was conducted for both the same.
Maybe, but
My
still
lord.
option is given. The very meaning of that restrict which my
Yes, my
sir
lord.
has said.
Yes, my lord. I bow
according to
down.
you,
I bow down.
according to you, when you metamorphose to both persons, because the qualification is different,
They are not
Yes,
interchangeable.
choice is different.
Yes, my lord.
Suppose in civil service,
Yes,
in civil service, one will argue that since IAS, IFS, and IRS are all equal, all promotions are to be equal, even in state.
No, promotions, I'm not on that
So that
point.
is difficulty because your argument is that if it is through a one recruitment process, one examination,
Yes, my lord.
then whatever may be the application,
Yes,
whatever may be the choice,
Yes, ma'am.
all promotions are to be equated.
my
That
lord,
never happens in service.
yes, my lord. I bow down.
You
My-
show a single instance of any citation, any
Ruling.
authority, any ruling.
There cannot.
My lord,
Even now,
My
the
lord.
difficulty, Mrs. Patnaik, is that suppose in medical faculty,
yes, my lord.
a surgeon becomes much after a professor than somebody in non-clinical subjects like biochemistry, Is it not discriminatory?
My lord,
Because even so.
My lord,
No, you are missing actually. You are missing the woods for the trees. You look at postcode 5. What we have applied for.
Yes, my lord. My lord, my first submission. Yes, my lord.
Saying yes, my lord, you are not looking at that.
Yes, my lord. I understand.
To you, when it became equals.
My lord,
never equal.
No, my lord, equal means, my lord, kindly have the eligibility. Eligibility, my lord. Bachelor's degree in science.
Let us not shift from one place to other. Has finished 29. Let us have interpretation of 29.
On that point only.
So can you read that?
My lord.
Kindly read that asterisk.
Yes, my lord. Postcode is for operator. My lord, my submission.
You are not listening, that's the problem.
My lord, I am coming to that point. My lord.
Code is not for the operator, is it the question?
No, my lord, it is not the question.
What is the operator? Is that their case also?
My lord, because I will draw my argument from the post of operator only. My lord.
Drawing argument, yes, definitely. Otherwise, you have no case.
Yes, my lord.
That's not. We are not discussing. Says.
Yeah, my lord. Bachelor's degree in science, BSc with computer.
No, you are not reading. You are reading something else.
Postcode 5, my lord.
You are not reading what is being pointed to you. Asterisk.
Yes, my lord.
Stop.
That is for laboratory function and for general function, my lord.
Read further. Don't.
As per the essential requirement mentioned against each function. Yes, my lord.
Now kindly mark ABC.
Yes, my lord.
ABC, your qualification, essential, everything is different.
Yes, my lord.
Even then they should be acquitted.
My lord, my submission would be here now. On what post they are working now? They are only operators in the laboratory to help with the equipments, my lord. Only that is their position. They are not scientists. They are not any technical persons. My lord, if an attendant...
Who to decide that? Court or the authority or the recruitment?
Because from their position in the selection list...
You have to cite some precedents. Actually.
My lord, kindly have a glance to... They have not annexed in the manpower, what is as per their submission, that they are coming under the category of scientific and technical category. My lord, as per their submission. And in the manpower sanction, the sanction of the...
Why can't you little be slow?
Yes, my lord. Sorry, my lord. No, my lord. Sorry. Sorry, my lord. I apologize.
If you identify yourself too much with the interest of your client, this happens.
No, my lord, I apologize.
Be slow.
Yes,
it's an interaction.
Yes,
keep your emotions aside.
Yes, my lord.
Argue intellectually. We will treat it intellectually.
Yes, my lord.
Is it not?
Yes.
Now we are asking you. You admit that in terms of recruitment notification, educational qualifications are different. You admit or you do not admit?
Yes, my lord.
You admit.
Yes, my lord.
That educational qualifications prescribed for those people is different from those prescribed for your people. Do you agree?
Yes, my lord.
Do you honestly agree?
Yes, my lord.
Number one. Number two, kindly come to that asterisk.
Yes, my lord.
Kindly read it again.
For the postcode 5. Applicants has to mention their area of interest on the application form. That is for laboratory function.
One.
Yes.
That is one for
laboratory function.
2 laboratory function.
For general function, as per the essential requirement mentioned against each function.
Number.
Yes.
Stop there. Kindly come to your application.
Yes, my lord.
Kindly see the application. For which post you have applied?
I have applied for the general function.
Recruitment notification says general and technology scientific.
Yes, my lord.
There is a asterisk which says an option is given. That option you have not exercised. Number 3, your application is for a particular post. And learned single judge says this post and that post are one and the same. How? That runs counter to the service jurisprudence.
My lord, my only prayer was there. Since we are all appointed as operator, why the promotion has given to them in the year 2014? Why our promotion, which was formulated as per their governments in the year 2018, where operator...
One second. Your
Promotion to the next level is to what post?
My lord, that is as per the 2019, my lord.
This
That is
happened-
LDC.
LDC.
Yes, my lord. But
Their promotion is to what post?
technician B.
Even feeder cadres are different now.
No, my lord, they have operated. My lord. My lord. They have redesignated from operators to technician B.
Which operators?
These all the recruiters, this advertisement, under this advertisement, those candidates have qualified. They all were issued with one appointment letter as treating them as operator, because the manpower sanctioned for the operator.
Where is your select list? Very notification that virtually amounts to rendering the wisdom of the person who drew this notification.
My lord, kindly have a glance to page 121, the sanction strength.
Mrs. Patnaik, what would be your answer to lecturers traveling in different directions? All are lecturers. There is one cadre even.
Yes, my
One
lord.
recruitment rule. Kindly,
Yes,
if you know the question, then you can answer it. So
my lord.
I think you do not know what I'm thinking. I'm asking you.
Yes, my lord.
What is the question?
My lord, question is that the recruitment.
No, that's not the question. You are framing the question. You don't put words to my mouth. In any service jurisprudence, suppose selection of lecturers in medical college, engineering colleges, all are lecturers. And in fact, here also the eligibility criteria maybe it is still different. There also it is only one qualification, say doctorate or something in the subject. So they appointed as lecturers.
Yes,
but
my lord.
every lecturer gets a promotion on different day. What is the answer to that? So this is discriminatory.
Yes, my lord.
Because all are lecturers. So all the system is discriminatory.
My lord, my only submission to this that they are also functioning as clerical post. We are also functioning as clerical post.
Why do you
But
require so much of
but the post
justification?
are-
Why do you require so much of justification if you are equal?
Because I am only justifying why they will be given promotion in the year 2014.
Antedating your promotion is a different claim. You see, suppose one lecturer is not getting promotion for 5 years.
Yes, my
There
lord.
is a vacancy.
Yes, my lord.
So, Rangaya, you cite and get promotion from a particular date, that's a different. But you are saying since lecturer in English gets promotion in 2024, all the lecturers in the same university or the same cadre,
Even same case.
same cadre, same promotion in 2024. It never happens. It has never happened yet to happen actually.
My lord, let this come another day, my lord. I'll
No,
satisfy.
kindly show that your appointments, that select
Yes, my lord.
list, where you have been selected.
Select list is not here, my lord. Only the number of candidates who have already completed their probation, my lord. That is there, my lord. Because all these are in the select
Yes,
list.
this is for hearing.
Yes, my lord.
Oh, yes.
My lord, another day,
Wait,
my lord, another I'll satisfy me on this.
tomorrow?
Tomorrow, my lord.
Monday.
My lord, Tuesday.
Tuesday. Wednesday.
Which day you want?
Monday or Wednesday? Tuesday.
Wednesday.
Yes, my lord.
For the hearing before this very late. At the request of Learned Counsel representing the respondent employees.
I file this case. There is flag C because they moved the content, file a content. Granting 1 more time to comply the order.
Till next date of hearing, the included order is
Public.
Item 31